जी सर।
Lots of this is the releasing of vehicle of uploading the cattle.
आप कैटल्स
No, lots of the kindly P3 lots of the vehicles was rent out by the another Mr. Mukesh. The conditions has already made in the petition, lots of affidavit to
वो
cattle.
कहाँ है रेंट नोट सर?
Lots of P3 page
हाँ
number
जी।
20.
जी।
इसमें लॉट्स ऑफ पेज नंबर 22 में पैरा 5 में हमने उस जिसको किराए से वाहन
This
दिया था,
है
जिसको वाहन किराए से दिया था, उसको खास तौर से इस चीज के लिए मना किया था।
क्या लिखा था?
ये पैरा 2 पेज नंबर 22 पैरा 5 में यह कि उक्त
हाँ
वाहन
ठीक
कुछ
है।
वाहन
अब
स्वामी
आपकी
द्वारा
जब गाड़ी जब जब कॉन्फिस्केट हो रही है तो उसकी कीमत इन सज्जन से वसूलो ना, कौन मना कर रहा है? क्योंकि इनके जिम्मेदारी थी, तो ये एग्रीमेंट आपका और ये प्राइवेट मुकेश के बीच में है, शासन तो उससे बाध्य नहीं है ना सर। तो शासन तो बाध्य नहीं ना, थर्ड पार्टी तो बाध्य नहीं है ना सर। तो आप मुकेश के खिलाफ मुकदमा लगा के कीमत वसूल लो कि तेरे चक्कर में मेरी गाड़ी कॉन्फिस्केट
फरार
है।
वो अभी तक गिरफ्तार नहीं हुआ।
तो नहीं हुआ तो हुआ। आप ये बताइए इस रेंट नोट से क्या शासन बाध्य है? गवर्नमेंट इज नॉट द पार्टी टू दिस। If he has committed an offense and the vehicle is liable to be confiscated, so you can recover the amount from this person. कॉन्फिस्केट हो जाएगी तो फिर वो देखी जाएगी, आप इनसे वसूल लीजिएगा, उसमें क्या है?
मतलब कलेक्टर इज ट्राइंग टू
हैं?
destroy the
हैं सर?
collector is trying to disposal the vehicle.
हाँ तो क्या हो गया, गवर्नमेंट को अपना काम करने दो, आप मुकेश जी से वसूल लीजिएगा कि हमारा और तुम्हारा एग्रीमेंट था कि हमें नुकसान नहीं होना चाहिए, तुम्हारे कारण से नुकसान हुआ, इतना पैसा दे दो हमको। दो प्राइवेट लोगों के बीच का एग्रीमेंट गवर्नमेंट के ऊपर कैसे लागू होगा? दैट इज द ओनली क्वेश्चन।
One judgment of this court.
अब आप कहोगे कि सर हमारे नॉलेज के बगैर कोई ऑफेंस हुआ है तो इट इज नॉट लायबल टू बी कॉन्फिस्केटेड। यही आर्ग्यू करोगे और क्या करेंगे सर? उसका भी आंसर है मेरे पास, आप आर्ग्यू करो तो उसका आंसर आ जाएगा।
The learned trial court has been rejected the revision of the petitioner on the ground that न्यायालय के समक्ष प्रस्तुत रजिस्ट्रेशन और आधार कार्ड की मूल प्रति
जो भी
पेश
रीजन
नहीं की गई,
तो जो भी रीजन
जब्तशुदा वाहन के संबंध में
कार्रवाई शुरू हो चुकी है। जो कॉन्फिस्केशन प्रोसीडिंग स्टार्ट हो चुकी हैं तो वो अब वो है सर। अब ये मुझे कोर्ट कैसे करेगी? कितने जानवर मरे थे इसे और कितने जानवर मिले थे उसमें से? 8 गौवंश पिकअप में, कुल 8 गौवंश, छोटी पिकअप, 3 गाय, 5 बछड़े ठूस ठूस कर निर्दया पूर्वक मुंह व पैर रस्सियों से बंधे हुए पाए गए। फिर सर 15466/2024 this petition under under section 482 of CRPC has been filed। क्या है सर इसमें? इसमें कौन सा पैराग्राफ बताएंगे आप सर?
पैराग्राफ 18 और 19,
ये
पैराग्राफ 18 और 19,
18 and 19 जी सर। वो तो सुंदर भाई वाला है ना, मालूम है ना सर। तो आपने तो खुद ही एग्रीमेंट कर रखा हुआ है। मैं ये तो कह रहा हूँ आप एग्रीमेंट को एनफोर्स कराइए ना, प्राइवेट कॉन्ट्रैक्ट है आप दोनों के बीच में। सुंदर भाई वाला जजमेंट तो तब लगेगा कि जब आपके राइट्स कहीं प्रोटेक्टेड ना हो। आपके राइट्स तो आपके एग्रीमेंट में प्रोटेक्टेड है शर्मा जी। 15466/2024. This application under Section 482 of CRPC has been filed against the order dated 22/3/2024, passed by Session Judge Raisen in Criminal Revision number 8/2024, arising out of order dated 12/3/2024, passed by JMFC Raisen in crime number 556/2023, registered at police station Raisen for offense under section 11 bracket में 1 bracket में D of Prevention of Animal Cruelty Act 1960, as well as under section 4, 6 and 9 of Madhya Pradesh गौवंश वध प्रतिषेध अधिनियम, comma under section 4(6) of Madhya Pradesh कृषक पशु परिरक्षण अधिनियम, and under section 66/192 of Motor Vehicle Act. It is submitted by counsel for the petitioner that petitioner is the registered owner of the vehicle pickup model 2014 having registration number MP13GB6311. The said vehicle was let out to Mukesh with a clear rider that in case if any legal proceedings are instituted on account of illegal work done by him, then Mukesh would be responsible for the same. It is submitted that although the proceedings for confiscation have been initiated, it is submitted that on 5/1/2023, as an information was received that one pickup which is parked by the side of the road is carrying cattles, 8 cattles, that is 3 cows and 5 calves with their mouth and legs tied. The vehicle as well as the cattle were seized. Police system. It is submitted that it is true that the confiscation proceedings have been initiated, but there is no bar for release of vehicle merely for the trial court merely on the ground that confiscation proceedings have been initiated. It is submitted that once the cattle were being transported without the knowledge of the petitioner, knowledge and permission of the petitioner, then prima facie he is not guilty of the illegal act of Mukesh. To buttress his contentions, the counsel for petitioner has also relied upon an order passed by a coordinate bench of this court in the case of Milind versus State of MP, decided on 2nd of September 2022 in MCRC number 41986/2020. And it is submitted that in the light of judgment passed by the Supreme Court in the case of Sundar Bhai Ambalal Desai versus State of Gujarat, reported in AIR 2003, Supreme Court 638, the vehicle should be seized. It should be released. Heard the learned counsel for the petition. The Supreme Court in the case of Abdul Waha versus State of MP, reported in 2022 SCC Online SC 262, has held that the object of the confiscation is punitive of 2004 Act is punitive and deterrent in nature. Section 11 of 2004 Act and Rule 5 of MP Govansh Vad Pratishedh Rules 2012 allows the seizure and confiscation of vehicle in case of violation of Section 4, 5, 6, 6A and 6B of the Act. Therefore, in order to put an effective check on the commission of offense, the separate provision for confiscation has been made for the system. It is the case of the petitioner that it was not within his knowledge that the offense is being committed by Mukesh. In the considered opinion of this court, it is difficult for this court to give any finding in that regard because the confiscation proceedings are still pending. Even otherwise, the rights of the petitioner are protected by virtue of an agreement executed between him and Mukesh. As per clause 5 of the said agreement, Mukesh was made liable for any legal proceedings on account of any illegal work done by him. If the vehicle stands confiscated, then the petitioner can recover the value of the vehicle as well as the loss which he may suffer from Mukesh. But since state was not a party to the agreement, therefore the said agreement cannot be made applicable to the state authorities. Since the rights of the petitioner are already protected under the rent note executed between the petitioner and Mukesh, this court is of considered opinion that in case if any loss is caused to the vehicle on account of parking in open area, any damage is caused to the vehicle on account of parking in open area, still the petitioner would not suffer any irreparable loss and he would be entitled to recover the value of the vehicle as well as the loss sustained by him from Mukesh. In considering the totality of the facts and circumstances of that case, this court is of considered opinion that no case is made out warranting interference. The application fails and is hereby dismissed.
Item number 23. May I please, Lord?